I'm delighted to be joined by Zoe O'Sullivan, who many of you know well. She's going to be talking about early determinations under the new LSDI DIFC rules. I'm also joined by Gregor Hogan, who you know well, and he's going to be talking about foul, oil and sewer and some of the lessons that we can learn from that. I'm talking about the freezing injunction and offering some top tips on that. I will move at a fair canter, and I'm going to try and take it at a fairly high level because you are obviously very familiar with this jurisdiction. My first tip is obviously on the importance of critical path at the outset. That's working out who is doing what. There is a need to multitask. Ordinarily, a counsel team are working on the skeleton, solicitor team on the supporting affidavit, and there needs to be liaison with the registry in terms of getting a hearing in the diary. And obviously, it's important that there be some coordination and project management at the outset, because everything has to sort of fit together. And if it doesn't, it results in a lot of work at the end of the process. This is important, obviously, because of the issue of delay. Historically, delay was a big problem, and the court sometimes took a rather punitive approach in saying, well, where's the risk of dissipation given that you've taken 6 weeks to come to court? The DIFC court's been a little bit more relaxed on the issue of delay, and I think common law courts now are moving in that direction. The punitive sense has gone. The issue is whether there is a current risk of dissipation, and there are those cases from 2012 and 2014, Madoff Securities and Ravens, endorsed by the Court of Appeal in Pugachev, where the court found that even if the delay increases the risk of dissipation, it's only one factor in deciding whether to make an injunction, and the court is still entitled to close the gate, figuratively, even if only to stop the escape of the final miniature horse. Now, I should say risk of dissipation has also broadened in terms of its canvas. We have seen in the DIFC court particularly references to congentra and the second limb of that case, and risk of dissipation can also be considered by reference to the discreditable conduct of the respondent. Now, obviously, in a jurisdiction like the DIFC, where there's a lot of arbitration, where a respondent has been guilty of, for example, guerrilla arbitration, then that may be significant in terms of trying to show they are discreditable. They're the type of defendant, the type of respondent who will stop at nothing to frustrate enforcement, and therefore there is a risk of dissipation. My second top tip is to consider joining the banks. I don't need to tell you this. The leading cases in which this has happened are SBM and NBK, and obviously LARMAG and FAB. And in passing, well done in the trial in LARMAG. I think even as a former opponent in that case, I can say that was a job extremely well done. So joining the banks. Now, we've seen some very innovative jurisdictional hooks in order to join banks. So, for example, in NBK, the claimant nominated repayment to a DIFC branch of its bank, and that was found to create a jurisdictional hook because part of the contract was therefore to be performed in the DIFC. FAB and LARMAG, again, it was found that a UA bank, merely by reason of being recognized by the DFSA, was a licensed DIFC establishment for that purpose, and therefore that founded party jurisdiction under 5A1A. Again, maybe controversial, but in my view, that was a rather innovative approach, endorsed, I should say, by the Court of Appeal. Now, what I think, when we're talking about fraud, obviously there's an argument that the bank receiving money is potentially a cause of action defendant under a proprietary claim. But I think what we're beginning to see is the beginnings of a Chabra jurisdiction. That's to say, a jurisdiction to make a freezing injunction against a non-cause of action defendant, where there's good reason to believe that there are assets in the hands of that non-cause of action defendant susceptible to a process of execution to satisfy judgment. So the case law, if you like, isn't settled, but we are beginning to see banks being joined in circumstances where there's not a lot of emphasis on any proprietary claim being advanced against the bank. And indeed, where subsequently a bank interpleads, that rather makes the point that there is no substantive claim being pursued against the bank. My third tip is to consider at the beginning whether you will be looking, my third tip is dealing with winter cap jurisdiction. So if you are seeking a freezing injunction, in respect to foreign proceedings, you'll need to consider the issue of expediency, which is a sort of a broadening, if you like, of the just and convenient test. We've seen an increasing number of winter cap cases where the court grants an injunction in support of foreign proceedings. The IMS and BankMed case, and there's another case, which is an arbitration case, where the judgment went briefly onto the website and was then taken down again quite quickly. It's a shame there isn't as yet a nice written judgment setting out the basis of the winter cap jurisdiction, but I'm sure that will happen fairly soon. We do need to look at the jurisprudence under Section 25 of the CJJA in terms of what are the tests. And obviously within the expediency test, the court has to consider whether there is a real and substantial connection to the jurisdiction, in this case to the DIFC. So we might see more emphasis on what is this injunction in support of proceedings over there doing, and why is it being brought over here? There needs to be some form of real connection. Fourth tip relates to asset disclosure, and the tip is don't abuse it. I think it is sometimes abused. Often it's used really in order for the claimant to work out whether they have any real prospects of recovery, to try and work out where the assets are, if there are any. It's also sometimes used to set up a committal application, because that's perceived as being a way of applying pressure. It ought to be about working out where the assets are located so they can possibly be further secured if that's necessary. Now, from the respondent side, if you're facing an asset disclosure order, it's important to comply. Sometimes respondents think, well, if I'm contesting jurisdiction or I've got some other issue with the validity of the freezer, I don't need to comply with the asset disclosure order. That, in my view, is wrong. Occasionally you get judgments where there's a little bit of judicial sympathy with that point of view, particularly where there's been where it's dealing with an ex parte order. But from the respondent side, if you don't comply, firstly, you risk a committal application. That's obviously a topic in its own right, but that is a risk. Secondly, you may have difficulty getting the indulgence of the court if, for example, you want to vary the order at some point, and that was raised recently in a case of SBM and Renish. And thirdly, there's a further risk of being cross-examined on any affidavit as to asset disclosure under RDC 3.4. You don't see that being used very much, but it is there, if you like, in the arsenal. Fifth tip, it deals with exceptions. As a claimant, in my view, should be reasonable in terms of the exceptions you're willing to grant. There is a certain judicial nervousness about freezers, but that can be tempered to some extent if you're reasonable in terms of the exceptions. The main exception is the ordinary conduct of business, the OCB exception. That was, again, explored in the SBM litigation recently. It's not mandatory. It's in square brackets in the standard form order. The court found that the exception is usually included, but it may not be necessary, and it may not be appropriate. If, for example, the respondent has no business or has no legitimate business, there is no need for an OCB exception. And to some extent, the DIFC court is moving with the English courts, and one sees a direction towards the burden of persuasion, if you like, being on the respondent when arguing for greater or wider exceptions. My sixth tip relates to notification orders, which can be used to support a freezing injunction. Now, there has been over the years an issue as to whether a freezer affects assets held through a company structure. Now, and there's that bit in the standard form, I think it's paragraph 5 or 6, which suggests that maybe because they're under the control of the respondent, those assets are affected. Well, the Court of Appeal in Lacatamia in 2014 said, well, no, that it doesn't affect those assets. And then there was a sort of an issue, well, in that case, how do we freeze assets that are held through a corporate structure? And in a subsequent case, FM Capital Partners and Marino, the English courts said that where there is a sufficient degree of ownership and control, then the assets held through a company may be enjoined. And that provides a justification for a notification requirement. So if the respondent knows that the company is about to dispose of the assets, then it's required to give advance notice. And it's a very useful addition to any freezer. It's useful both in respect of assets held through a company, but also in policing the OCB, the ordinary conduct of business exception. So again, if there's going to be a major disposal of assets, you can ask for information before that disposal happens. And indeed, in a judgment that Gregor and I were involved in before Mr. Justice Zaccaroli last year in Sesven Ventures and the Clayfeld Hague, a case with a strong Dubai connection, Zaccaroli said that the freezing, so the notification order was part and parcel of the policing of the injunction, but was also part and parcel of the disclosure obligation. So critically important, and as I say, where courts are nervous about freezing assets, sometimes you can deal with that nervousness by proposing instead notification, and then when a particular disposal is proposed and is notified, then it may be that the claimant at that point needs to go further and seek the freezer. Seventh tip is to consider foreign enforcement at the outset, particularly in the DIFC context. Is this a freezer that you're going to want to take into onshore Dubai or into the UAE? Now, there used to be a requirement that the respondent have assets in the jurisdiction, that's in the DIFC. So there was this rather unseemly inquiry as to whether they had some sort of bank account in the DIFC. And you see that, for example, in Boston. That is no longer the case. You'll remember the banyan tree judgment, where you can enforce an award even if there are not assets in the DIFC. That is, if you like, extended into the freezing injunction jurisdiction. And Wayne Martin, in the CBD and NMC and Shetty case, with which many of you will be very familiar, found there was no requirement to show that the respondent has assets in the jurisdiction. And you'll remember that was by reference to Western Australia Supreme Court judgment that I think Keith dug out. That has been followed now by Justice Shamlan in a recent arbitration case. So that does seem to be widely accepted within the DIFC judiciary. In terms of foreign enforcement, obviously, if you are seeking permission to enforce in Dubai, there are some real advantages in that. First of all, you can potentially get a precautionary attachment. But secondly, that is going to assist if you need to establish the potential liability of third parties who've got mixed up in a disposal. And that's because of the Babanaft proviso. And thirdly, it may undermine any attempt to to disrupt enforcement, either by the respondent bringing their own Dubai proceedings and then making a JJC, a judicial committee, joint judicial committee application. And we have found that if you already have enforced a freezer in the Dubai courts, it then becomes much more difficult for the other side, the respondent, to set up that alleged jurisdictional conflict. My eighth tip is to avoid fair presentation paranoia, as it's sometimes called. Obviously, it's true that presentation needs to be fair and even-handed. It's not enough simply to exhibit documents somewhere at the back of the affidavit. The court will set aside an injunction if it's found that there's been substantial or deliberate failure in terms of presentation. Having said all that, the courts have recently insisted that that there needs to be a due sense of proportion. And the real question is whether the court has been misled in a material respect. And the overriding consideration is obviously justice. It's not about teaching counsel a lesson if counsel has got something wrong. And unfortunately, these matters tend to become very personalized. It's about the interest of justice should still lead the debate, if you like. My ninth tip is a return date required. You'll be familiar with RDC 2512, which has this very strict requirement of return date after 3 days from an ex parte order. That created all manner of problems after the Pearl Petroleum judgment suggested that if the respondent was in a Riyadh country, you needed to effect Article 6 Riyadh service. Happily, Lahila and Lamise has swept away that part of Pearl Petroleum. But what has emerged in the meantime is a practice, an emerging practice, of instead of having a return date, including a permission to apply. So the respondent, as and when they are notified or served, can come to the court and say, well, this needs to be set aside, or this needs to be varied. And obviously, there's been greater use of alternative substituted service. So that's another means, if you like, of dealing with the issue about whether the respondent has been properly served or notified. And finally, my 10th tip is to raise the question, does the cross-undertaking need to be fortified? And the presumption is yes. There is one wrinkle which is interesting, which is that if it's a post-judgment freezer, and then the respondent has the security of the judgment debt, which can be a very significant sum, and that usually covers the potential exposure, certainly at the ex parte hearing. So the Nomehold has been followed in Bossimar it was followed by Chadwick. So good authority there. The further wrinkle is that if you're dealing not with a post-judgment freezer, but a post-award freezer, there may be more of an issue about the solidity, if you like, of that award debt because of the likelihood of an application to set aside the award. And therefore, the court in those circumstances sometimes looks at the issue, the prospects, if you like, of a potential or real application to set aside the award. So those are my top tips. The freezing injunction jurisdiction is an important part of the armoury of the DIFC court. It needs to be nurtured by all of us in good practice. Without more, I shall hand over to Zoe, who's talking about the DIFC LCA rules.
Zoe. Yes, and specifically about the interesting topic of summary judgment in international arbitration. So obviously we're all familiar with the power of the court to grant summary judgment in a case where the claim or defence has no real prospect of success. But there's not traditionally been equivalent powers under arbitral institutional rules. That is, I think, because of a concern about due process challenges. The concern is that it will be said that if a claim is decided on a summary basis, the disgruntled party will be able to argue that they have not had a fair opportunity to put their case. But nonetheless, obviously, that's a very useful power, and there has been pressure from arbitration users to introduce powers equivalent to those of the courts. And we see that the arbitral institutions have been responding to that demand, with the charge being led by ICSID in 2006. So looking then at the DIFC's version, the DIFC LCIA, that has come in with the 2021 rules, and it's one of the additional powers conferred on the tribunal under Article 22.1 Roman 8. And you'll see that there are three circumstances in which this power may be exercised. Firstly, where the claim, etc., is manifestly outside the jurisdiction of the arbitral tribunal. Secondly, where the claim or defence is inadmissible. And thirdly, and probably most usefully, where the claim or defence is manifestly without merit. And we'll look into what each of those means in due course. For the moment, I just want to point out that there's also reference to the early determination power under Article 14.6, where it's listed as one of the general powers of the arbitral tribunal. So there isn't very much authority on the application of this rule, although that will change as enforcement decisions are rendered by the DIFC and other courts. So it might be therefore useful to look at what's available in terms of such powers under different rules. And as I said, the people who first breached this subject were ICSID. In 2006, they introduced their Article 41.5 rule, quite long and elaborate. But key things to note here is that it applies only to claims, not to defences. Secondly, that there's a strict 30-day time rule for filing the claim after the application, after the constitution of the tribunal. And thirdly, that it's related to an objection that the claim is manifestly without legal merit. And as we shall see, the DIFC LCA rule is not so limited. So there have been some very useful decisions on the meaning of manifestly without legal merit. I mean, it seems pretty clear without looking at authority that this is intended to impose a high threshold, and that it means it's confined to cases where the claim or defence doesn't disclose a cause of action or defence as a matter of law. In other words, it's rather like what under court procedures we would call a strikeout application. It doesn't apply, for example, where the defence is said to be shadowy. And of course, the reason why there's a high threshold is that the party who's the subject of the application is being deprived of a full opportunity to present their case. And so obviously it needs to be reserved for clear and obvious cases. And we see for the first case to consider the meaning of the ICSID rule was Trans-Global Petroleum and Jordan, and they confirm, as you might expect, that the standard is set high and that as a basic principle of procedural fairness, an award can, under the rule, can only apply to a clear and obvious case. And that was echoed in a much more recent decision of Lotus Holdings and Turkmenistan from last year, where the point is made that the claim is struck out because it cannot succeed. There's some fundamental flaw in it, which means that it cannot proceed any further. And other institutions have followed in the footsteps of the DIFC LCI, of the ICSID rather. As we see, the first up was the Singapore International Arbitration Centre in 2016. In rather similar terms, it allows the early dismissal of a claim or defence, which is manifestly without legal merit, and they add to that a power to dismiss where it's manifestly outside the jurisdiction of the tribunal. And you can see that Hong Kong in 2018 grasped the nettle of applying this to factual disputes, where the point of law or fact is manifestly without merit. The ICC, while not amending its rules, has indicated in its note to the parties that the ICC tribunal has similar powers where the claim or defence is manifestly devoid of merit or manifestly outside the tribunal's jurisdiction. You see again the similar wording. And then finally, for completeness, the Swedish Chamber of Commerce introduced its similar rule, probably the broadest possible version, in 2017. Again, extending not just to claims which are legally hopeless, where the facts don't support the cause of action or the defence. And you'll note the final power given to the tribunal under those rules is extremely wide. It basically is, for any reason, that the case is suitable determination by way of summary procedure. And the DIFC LCA rules are not quite so broad, as we'll see. So as I've said, the DIFC LCIA power applies in 3 situations, which I've set out in this slide. And let's look at those in turn. So the first is that the claim or defence is manifestly outside the jurisdiction of the tribunal. Now that might arise, for example, where it's obvious that a party who has been joined as claimant or defendant is not actually a party to the arbitration agreement. That might be an obvious case. On the other hand, that might well give rise to factual disputes, but it's possible also to imagine some legal question which is suitable for summary determination, such as whether one party has succeeded to another, whereby by novation or succession or some other legal reason. But it's difficult to see what this new power adds to the existing armoury of the tribunal, in that the tribunal already, under the existing rules, had the power to order a preliminary issue on jurisdiction and would often do so. Again, this particular addition doesn't seem to strengthen the existing powers. And arguably, manifestly outside the jurisdiction possibly sets a higher hurdle than a preliminary issue. So you would query why you would want to go down this route. Well, the second instance is where the claim is inadmissible. Now, admissibility in arbitration has been somewhat obscure until quite recently, and there's been a flurry of recent decisions in several common law jurisdictions which explains what admissibility is, and it's usually contrasted with jurisdiction. So, for example, the Singapore Court of Appeal, in the case I've cited there, says jurisdiction is commonly defined to refer to the power of the tribunal to hear a case, whereas admissibility refers to whether it's appropriate for the tribunal to hear it. So the classic instance is where you have a tiered dispute resolution clause which has not been fully exhausted. And so it's the tribunal, there's no question that the tribunal will in due course have jurisdiction over the dispute, but the reference to arbitration is premature because the dispute resolution process has not been exhausted. Another case where the claim might be said to be inadmissible is where it's time barred. Clearly, the tribunal has jurisdiction to consider that question, but it is in effect saying that it should not hear the claim because it's time barred. But again, as with the jurisdiction point, because the tribunal already has powers to direct the determination of a preliminary issue on limitation, it's difficult to see that the early determination rule adds very much to the existing powers. Where I think the power is going to be most useful and the most controversial is the third category, where the claim or defence is manifestly without merit. And we see immediately that unlike the ICSID rule, it's not limited to claims or defences without legal merit. So in other words, it is like a classic summary judgment power, where it can be said that although a defence has been raised which appears to raise factual issues, the evidence is so lacking, or the defence is so shadowy or implausible, as to make it suitable for summary determination. How will this new rule be interpreted? Because I'm currently determining an application of this nature under the LCIA rules as sole arbitrator, I've given some thought to it. And I've concluded, without the assistance of the ICSID decisions, that this is obviously for cases that are very, very clear. The hurdle must be high. I find the ICSID decisions extremely useful. I think it's unlikely that any tribunal would apply them directly, because obviously they relate to different rules with different words. But nonetheless, the indications in those decisions that it's for clear and obvious cases where the claim is, say, legally hopeless, that sorts of indications are very helpful for a DIFC LCIA tribunal. And there's also room, it seems to me, to look at the decisions on immediate judgment under the RDC 24. And just to remind ourselves what the test is, it's the hurdle, of course, is no real prospect of success and no other compelling reason why the case or issue should be disposed of at trial. Now, obviously, that is different, and arguably not the same as manifestly without merit. So because of the difference in wording, again, tribunals will be unwilling, in my view, to import the decisions on immediate judgment. But nonetheless, I think if you look at the cases, you will find a mine of useful dicta about the circumstances in which summary determination is or is not appropriate. And I've set out the GFH Capital and Hay decision, which was approved in the Investment Group and Standard Chartered Bank. Those cases, in fact, refer to a body of very well-known English decisions. And as I say, it's a rich mine to be looked at if you're the party either applying for or resisting an application for early determination. For example, it was said in ICI Chemicals and Polymers against TTE that it's not uncommon for an application to give rise to a short point of law or construction. And it's appropriate for the court, or in this case the tribunal, to determine that if it's satisfied that the parties have had an adequate opportunity to address it in argument. So thinking about the procedure then, now the 22.1, of course, this is arbitration. It requires the tribunal to give the parties an opportunity, a reasonable opportunity, to state their views. Now, query whether, as I thought in my own case, this is in essence a two-stage process, whereby first of all, the tribunal invites the parties to say whether early determination should be heard at all, and then proceeds to give directions and hear the application if it thinks it should. My thinking was that, for example, sometimes when you apply for a preliminary issue, you don't have that as a right, as you do with an immediate judgment application. You have to persuade the court that it's efficient and efficient use of time and resources to have a preliminary issue. For example, you've got to show that it would determine the case one way or the other. So query whether that is something which needs to be looked at an initial stage, or whether it's one simply leaps in, the application is made, the tribunal takes note of the fact it's been made, and then invites the parties to make their submissions on whether or not there should be an early determination. I mean, that procedure will be very much in the hands of the tribunal, but there will obviously be, given the process issues, be anxiety on the part of the tribunal to give the respondents a full opportunity to address the issues and say that it's completely unsuitable for early determination. And obviously, this is a case that's going to be, this sort of application will be determined on the basis of written evidence. There will not be oral evidence, although there may well be a hearing or not in the election of the parties. So the big question then is this going to be challenge proof? Well, I mean, the answer to that may depend on where you're trying to enforce the resulting award, assuming that there has been a summary determination. Looking at, for example, the New York Convention grounds for challenging an award, one of them under Article 5.1d is that the procedure of the arbitration was not in accordance with the agreement of the parties. In my view, that argument is not available to a party which has included a DIFC LCIA arbitration clause. because it can be said that they've contemplated and submitted the possibility of an early determination application. Query what would happen if the arbitration clause was entered into some time ago prior to the adoption of the new rule, but that's another case. But another and perhaps a more fundamental objection may be the ground under Article 5.1b of the New York Convention, which is that a party was unable to present its case. And that's an obvious ground of challenge for a party that feels that it hasn't had the full opportunity to develop its case with the benefit of oral evidence and document production and so on. So, and this is why, to ensure that, from the tribunal's perspective, to ensure a challenge-free award, or successful challenge-free award, I should say, it has to apply a high threshold and exercise the power only in very clear and obvious cases, and there will be the need for very full reasoning to justify the tribunal's decision to go down this route. And only if we'll have to watch this space in terms of the attitude of the courts to applications to challenge or enforce the award. I mean, obviously, an arbitration-friendly jurisdiction like the DIFC court is likely to uphold the tribunal's decision, unless there's been some obvious failure of due process. But I think it's a space that we will need to watch. And of course, you will have to bear in mind whether this is going to be enforced onshore or possibly in some other less arbitration-friendly jurisdiction. Anyway, it will be interesting to see. Potentially a useful power, but one to be exercised with caution.
Gregor.
Thanks, Rupert. As Rupert said at the outset, I'm going to speak about the decision in Fal Oil and Siwa. At the outset, I should issue a disclaimer that Rupert and I came a very close second in this case. The facts are pretty straightforward. Fal, as you all know, was a well-known oil company involved in the supply of petroleum products. Siwa is a legal entity constituted by decree in Sharjah with a monopoly on the supply of electricity and gas within that emirate. Fal was is in possession of a judgment from the Sharjah courts against Siwa in the amount of about 1.7 billion dirhams. That judgment had been upheld twice on appeal, including by the Sharjah Supreme Court. In its application, Fal sought ratification and recognition of the Sharjah judgment in the DIFC and the declaration that it was enforceable as a DIFC judgment. At the stage that we were involved, there was no attempt by Fal to actually use any of the execution procedures in the RDC. Siwa's main defense or main argument in resisting enforcement of the Sharjah judgment was that it benefited from sovereign immunity. This raised two immediate hurdles. The first being that in Pearl Petroleum, it had been expressed, albeit obiter, that the DIFC law did not have a concept of sovereign immunity. And secondly, Siwa was seeking to establish sovereign immunity on an inter-emirate, i.e. intra-UAE basis. Justice Wayne Martin started with the first issue, i.e. considering whether DIFC law did or did not contain a principle of sovereign immunity. He started by looking at the waterfall provisions in DIFC law number 3 of 2004 and found that English law would need to be applied to the question of whether or not sovereign immunity arose. He then, however, went on to endorse the observation of Justice Field in YYY and ZZZ, where Justice Field had commented that DIFC conflicts of laws rules are found or founded on the general principles of English law set out in Dicey, Morris and Collins. I'll just pause there to comment that that's quite an interesting way of looking and distilling relevant rules. It's quite civilian, given that Dicey, Morris and Collins is, of course, only an academic textbook. Some of the propositions in it are subject of debate between practitioners and academics. But we do now know where we find the rules that will be applied and which textbook we need to use. Justice Wayne Martin agreed with the observation in Pearl Petroleum that sovereign immunity, if it did arise, was a question of procedural law, and therefore the DIFC court was entitled to apply the principles of procedure it considers most appropriate. So there's a tension there between his reference to an apparent reliance on the waterfall provisions, which of course mandate that English law is the ultimate applicable law, and that broader principle that the DIFC court is entitled to mould its procedures in the way it considers most expedient. Following YYY, the correct principles are those set out in DIFC, and as it was, quote, uncontroversial, close quote, that sovereign immunity was recognised at common law, it followed that sovereign immunity was part of the procedural law applied by the DIFC court. So that was our first victory in having Pearl Petroleum disapproved. The second question then arose as to whether CEWA could in fact rely on sovereign immunity within the UAE. In this regard, English law has obvious limitations, given that England is a nation within a unitary state of the United Kingdom. It's not a federative state, unlike the UAE. Therefore, I was sent off to Lincoln's Inn Library to trawl the textbooks on to identify the principles and authorities from other common law jurisdictions which do have a federal structure. And we focused principally on the United States and Canada. In the United States, in the case of Franchise Tax Board of California and Hyatt in 2018, the Supreme Court in a 5-4 decision revisited its earlier jurisprudence and found that sovereign immunity can be applied as between states within the United States. Likewise, in Canada, the Court of Appeal of Alberta in a 2001 decision, Albaska and British Columbia, had found that one province was entitled to invoke sovereign immunity from being sued in the courts of another province, albeit in that context, sovereign immunity had in fact been filtered through the notion of crown immunity, which is a particular common law concept, which in most jurisdictions, at least in relation to the ability to sue the state, has been watered down. Despite our valiant efforts and researches, and with giving all due respect to our opponent, his detailed researches as well, Justice Wayne Martin decided to ignore most of those and said that the starting point had to be the UAE constitution itself. He recognised that each of the emirates had been a sovereign entity before federation, but also commented that the process of federation involved a surrender of some, but not all of their sovereignty. Accordingly, one could not approach the question of sovereign immunity on the basis that the emirates had no allegiances to each other or other obligations to each other, which would be this situation in relation to two unfederated sovereign entities. Therefore, the constitution had to be the starting point for determining the question, not the principles of customary international law. Interestingly, Justice Wayne Martin said that even if the common law authorities had been of any use, they wouldn't have taken him much further because there was a division between the United States and Canada on the one hand and Australia on the other in relation to whether or not sovereign immunity could be applied within a single state. Therefore, he turned to Article 99 of the Constitution, which deals with disputes between two emirates, and found that those are to be resolved by the Union Supreme Court. And given there was no principle recognising or contemplating a claim to immunity by one emirate in the courts of another, no such principle existed. So where does that leave us going forward for future litigation? Well, the decision, in my view, is welcome clarity following Pearl Petroleum, insofar that it confirms that, broadly speaking, English conflicts of law rules do apply within the DIFC, and that will be unaffected by the broader principles of conflicts of laws applied in the UAE as a matter of UAE federal law. Because you'll recall in Pearl Petroleum, one of the reasons why the court was reluctant to recognise sovereign immunity was that the UAE itself does not recognise sovereign immunity. In that regard, the judgment can be found is consistent with the Court of Appeal's more recent judgment in Laral and Listrin, where again, the court found that English conflicts of law principles are to be applied when determining whether or not a foreign judgment will be recognised in the DIFC. Likewise, in Lahila and Lamiz, the Court of Appeal again applied English common law principles, at least in part, to determining whether or not the Riyadh Convention formed part of DIFC law by focusing on the distinction between international law obligations on the executives as compared to the laws actually applied by courts. Justice Wayne Martin did go on to find that even if sovereign immunity had applied on an inter-emirate basis, he didn't find that CIWA was going to be able to rely on that. He made a number of interesting observations in relation to that. I'll just touch on two. First, he put particular emphasis on the fact that CIWA was a separate legal entity with its own corporate personality. And he said that more often than not, that would lean against a finding that in fact that body was from part of the state for the purposes of state immunity. And perhaps of more interest for the region was that Justice Wayne Martin doubted whether the monopolistic provision of public services such as electricity and gas supply could ever be considered to be an exercise of sovereign power at all, which obviously perhaps is a slight distinction between other common law jurisdictions and the jurisdiction and region in which the DIFC finds itself.
Thanks, Gregor. It's very interesting to the issue around commercial emanations of the state and whether they attract sovereign immunity. Because I think, didn't Cook in Pearl Petroleum say that, well, you can't apply the common law because the common law would effectively stop the clock because it would be common law pre-State Immunity Act 1978. And therefore you would have none of that issue, all of that law in respect of whether whether an entity is serving a commercial purpose or a sovereign purpose. But Wayne Martin doesn't seem to have any of that problem. He just went for the common law, and then he imported all of the jurisprudence, if you like, under the SIA. Is that a fair summary of a divergence between the two judicial approaches?
I mean, what Wayne Martin, sorry, that's very disrespectful.
Sorry, yes,
Justice Martin found was that you just sort of reach for the common law principles expressed by the Privy Council in the Gecker Mines case. But it's right to say that one couldn't import wholesale the English regime because it does involve statutory interventions. That being said, it was interesting in the Laral and Listrin case. Sorry, let me make sure I've got the right one. Yes, Laral and Listrin. In that case, again, a judgment of Justice Wayne Martin found that there was a common law principle that a judgment entered in breach of an exclusive jurisdiction clause would not be recognisable as a judgment for enforcement in a common law jurisdiction. But that's never been part of English common law at all. That was introduced by statute in England. So that was quite an interesting sort of sleight of hand. He sort of said, well, I'm applying all the English law principles and I'm applying DIFC, but actually DIFC's first set line on this, it says this has never been recognised in England. There's one case in Canada. So you can see a sort of hybridization where you find the rules in DIFC and you then sort of extrapolate them out. That's where it's probably a bit unsatisfactory to say that the DIFC's rules are a sort of a general statement of common law, because obviously a lot of this area is governed by statute. And you'll recall that our opponent made quite a lot of that, I think, about the fact that the State Immunity Act has sort of fundamentally changed the landscape in England.
Yeah. Thank you. So do you think manifestly devoid of merit? I mean, that does seem to me a much higher hurdle than the immediate judgment hurdle. And
yeah, I mean, I don't know if it's much higher, but it is. Yeah,
I mean, I can see from an initiative policy that parties have agreed to arbitrate and are sort of entitled to have their day before the tribunal as much, but therefore throwing out parties to arbitrations at a very early stage on the basis of the famous
it's difficult, isn't it?
Merit has us kind of see why the hurdle might be higher. But
the exit rules, some of the decisions talk about arguability, which I suppose is quite like a strikeout. I mean, essentially, if your case is arguable as a matter of law, or if it's obvious that there are factual issues, then you're not going to get it. So, I mean, I think in practice, it's going to be it may be quite limited simply because of that concern. But having said that, the fact that all the major arbitral institutions have adopted this change in recent years suggests an increasing acceptability of summary awards or amongst the international arbitration community. So there you are. Watch this
critically, I don't think DIAC has done it yet, has it? Although I think DIAC rules may be under review.
I'm sure they're thinking about it.
So I mean, that could be an interesting divergence between DIFC-LCIA and DIAC in Great. Well, thank you, everyone. It's been a real pleasure, and thank you for having us. And it's, as I say, a great pleasure to have these discussions of the issues in DIFC law and arbitration.